The Social Security disability judge lied when he denied your case. Do you have any recourse? I'm Jonathan Ginsberg, and I'm a Social Security disability attorney, and I frequently see comments on my YouTube channel and Facebook page where somebody will say, I got an unfavorable decision and that judge lied. He absolutely lied and misstated all kind of facts and denied my claim. What can I do? Well, let me rephrase or revisit that whole premise, and that is that the judge lied. I don't think that judges lie. I think what you have happening going on is a couple things. One is that when the judge issues a decision in your case, realize the judge did not actually write that decision. After a hearing, the judge takes his notes and sends it to a writer, somebody who was not at the hearing, who may be in Maryland or some other state, and they have lawyers, staff lawyers, and paralegals in cubicles, and they generate decisions using basically form language, template language. And the writer on that decision is going to make interpretations based on what the judge's notes say. So the decision may include statements that you acknowledge something that you didn't acknowledge. And it's frustrating because as far as you're concerned, the judge says, I said I was smoking marijuana every other day for the last 6 months, when in fact you said, I occasionally smoke marijuana the last 2 weeks. I smoked every other day because I was getting really nervous about this hearing, or something to that effect. And the judge miscalculated or misreported what you said. And that's going to happen. Here's the truth of the matter is, unless the misstatement that the judge said, the interpretation of what the judge said, is so totally off the wall and completely irrelevant to the decision, that's probably not going to be an appealable issue. Now, if the judge misrepresented something that you said completely, and it's factual that you said, the judge says the claimant acknowledged or stated he had not been to the doctor in the last 6 months, but their medical records showing that you had been every single month, that's one thing. But if the judge basically makes a conclusion about your testimony that you acknowledge that you are a regular user of cocaine, even if you denied it, that may be his interpretation. He may feel you're lying. And so he may have said, this is my interpretation of what the medical record said and what this person said. So a judge's interpretation and statement of his or her interpretation of what you said is not a quote-unquote lie. It's the judge's interpretation. You may disagree with it. The judge's interpretation may be completely wrong. The question is, does it rise to the level where if the judge found something different, that would mean that he would instead approve your case? So sometimes it is. Sometimes we have situations where there's so many misstatements in the decision that an appeal is warranted. But if a judge simply misstates something that is relatively minor, 6 weeks instead of 6 months, or misstates the type of job you had, but it's still an unskilled job, it's probably going to be a distinction without a difference. It's probably not going to make a difference. I don't think that you have, and again, there are obviously some outliers, but for the most part, judges are not trying to find a way to screw you over. They're trying to make an appropriate and correct decision. And most of them are not looking to damage you in particular, but they may not find you believable. And if a judge does not find you believable, they're going to basically say, this was something this person was not believable in. I don't believe anything else he or she said, so I'm not going to give what his testimony was any credit. I'm going to take what this person said or what the evidence said, and I'm going to make my own interpretation of what it means. And that's a lot of times what's going on. I think when you're approaching an appellate attorney, and basically if you get an unfavorable decision that has mistakes of fact, you want to approach an appellate attorney, someone who deals with the appeals council and district court, which is really a different type of practice than doing hearing work, because you're dealing with questions of law as opposed to questions of fact. When you're talking to an appellate lawyer and you want that person to take your case, rather than say the judge lied and take this all personally, you want to be very matter of fact about it. The judge misstated what I had testified to. There's errors in his reporting. There's errors in this decision, and make note of it. Don't take it personally, because again, I don't think most judges want to do the wrong thing. They want to do the right thing. But you want to show yourself as calm and detached and very logical about the decision, and you want to point out very in a factual way these are mistakes. And the appellate attorney is going to look at it and say, well, there are 15 mistakes here. I think that's enough. As opposed to somebody who's just offended that the judge, misstated the job title. They're not going to take you as seriously. So if you want to get somebody to take your appeal, you want to really be very careful about how you present it. And don't present it as you're personally hurt and you're offended, but that this is a matter of law. The judge made a mistake. And that's the best way to approach an appellate attorney. So the question is, if there's misstatements in your decision, there's misstatements of fact, there's misquotes, what you want to basically show is you want to look at that very calmly and logically and rationally, point those out to an appellate attorney, and that's going to give you your best chance of getting recourse and maybe success at the appellate level. But if you look at it and you take it very personally, the judge lied and he had it against me and so forth, appellate attorneys are probably not going to take you as seriously. So I don't do much appellate work. I mean, I typically will bring in other people to do it. I'll write appeals occasionally, but usually I associate other people. So this is not something that's going to really impact me one way or the other. But I do want people who've got unfavorable decisions to be able to find good help with appellate work. And again, whether it's me doing it or somebody else doing it, that is the approach you want to take to help get that appellate attorney to take your case. Hope you found this helpful. Again, I'm Jonathan Ginsberg. My website is ssdanswers.com. You can download my free Secrets to Winning Disability Survival Kit. Leave me a comment on this video. Let me know what you think, whether it's Facebook or YouTube. And again, if I can be of assistance to you, please let me know. Thanks a lot. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the Survival Kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include: how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know: how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.